Good afternoon. We will reconvene. When we stopped just before lunch, we were having a discussion about moving forward and providing the opportunity of comment from the different parties. So I don't know if the council present want to address us on that in any particular order.
So the council has no objection at all to the proposal that was put to Federated Farmers, that they be provided an opportunity to provide written comments subsequently, so that's not opposed at all. In terms of Ms Bennett's availability, the short answer is she has none.
But the wider team does.
So we had anticipated definitely covering off integration issues for the wrap-up hearing, and Ms Bennett's back the week before that. Certainly TPG is obviously available to deal with all of the substantive, all integration issues. But I also take the point that the panel's made, which is that there needs to be an end point. So having looked at the documents provided, I wondered if I might politely ask my learned friend to look at the proposal that a track changes final version arising out of the documents that have been provided might be given to the panel, and while I might normally offer for the council to do that, we are probably not in the best position to do that because of Courtney's travels. So that's where I got to.
Yeah, no, that helpfully aligns with where I was heading as well, which was Hokonui are very comfortable and supportive of written feedback from Federated Farmers and Transpower. We talked briefly about the pros and cons of planning conferencing, but I think it's more efficient and more pragmatic to get written feedback. And yeah, the only other accepting of the fact that you don't want the process to go indefinitely, so we won't seek another round of comment from Hokonui, but yeah, aligned to what my friend was saying, perhaps if our role is to provide you with the final track change version sought by Hokonui, so that there's no confusion over what's being sought.
How will that differ from Appendix H?
It won't differ. It won't really differ at all. Well, as my initial reaction, Ms Barron will need to work through it. But it's actually what our intent when we were putting together Ms Barron's evidence was to make sure you had it all in this bundle. So there's nothing else sort of floating around.
It's the track, right?
Well,
yes, I haven't gone through each rule and changed the wording. I've just requested.
Can we come back to that after then? We've talked to Ms Barron about what is in her evidence. Partly, I guess, to firm up our view, and we may get some clarity, further clarity, after the questions that we've got, and we can then assess what is the value of actually updating what we've already got.
You know, I understand the driver there. I mean, as I say, it would really only be to flesh out with particular track changes. Just thinking through that while everyone's pondering. Obviously, all that would be Hokonui Runanga's perspective. There may still need to be a property group lens put over the whole plan, but I'll leave that for my friend.
Yeah, and how does that fit with what is the property group intent, and you're in the process of drafting a memorandum to us where council will be providing the panel with a list of, and putting it out for feedback, providing a list of matters to be dealt with in the catch-up hearing, and that will then come to the panel, and we will add to our list and then issue a minute that says it. And in terms of the timetable, yeah, I'm sure it's high on your priority list, but the point of raising that is that we've got to be careful not to be duplicating the exercise. Yeah. So if the purpose of what we're looking at in the catch-up hearing is really the standardisation of terminology, and getting changing the inconsistencies versus actually changes in wording that are sought. And less is better in terms of what we put out for feedback.
Thank you. And that when I say integration, I think I'm trying to capture mostly those consistency of terminology, which Ms. Bennett mentioned earlier. And then if there is anything that's slightly more substantive, say there was a little lumpy issue that came out of one particular hearing which needed to be picked up and brought into the wrap-up hearing, then I would expect that to be clearly signalled in the minute to make sure that all submitters were interested in that topic, and that little side issue could then attend to speak on that if that was the case. So we would signal that in the memorandum which you are to receive, and then otherwise the general expectation would be everything else would be focused on consequential integration type matters. Can I just do one little tidy up as well? My understanding from Ms. McLeod yesterday was that she didn't feel that she hadn't been able to spend enough time with Ms. Barron's evidence, and that may be misunderstanding things, but I hadn't understood her to have a concern about the process that had been followed. So in terms of the final written comments, I had interpreted that to be a response to Fed Farmers' position this morning, as opposed to a written comments from Transpar and Fed Farmers. I thought it was just from Fed Farmers. So.
Yeah, well, given they've been actually attending the hearing, we thought it was appropriate to invite them in the expectation that given that they are actually taking a very narrow view of what's of concern to them, there may not be much of a response that comes from them, but that's their choice.
Just Transpar pulls in the infrastructure chapter a bit more, so for me that's that coordination part. So
Yep.
Thank you.
So while we didn't reach a final point then on how we move forward, it was a little couple of baby steps, so we'll come back to it.
No, it was helpful, and I may be about to do a 180 on my plan of attack, because I looked through we can tie it off at the end of our presentation, but Appendix G, if the property group are going through a plan-wide audit, if a lot of Appendix G is almost just working through each row and ticking off where deletions are sought, so I can see the challenge of duplication if Hokanui are doing that and the property group are doing it.
And we'd anticipate, so the process, and you weren't here last week, so I apologise for not explaining that, and I shouldn't actually be directing this to you.
It's okay.
The process that was proposed for the panel was that a memorandum would be filed on behalf of council proposing what would go in the wrap-up hearing for all parties to then comment, and then for the panel to issue a minute. So perhaps that's somewhere else that you'll have the chance to speak about what gets captured or not captured anyway. So procedurally, that's all very open, I would submit, and that's the intent.
No doubt to all start landing soon. Yeah, I'll just find my submission.
But we have felt today has been extremely helpful in helping us focus
Great.
or
Yeah.
bring it to the sharp point.
And I appreciate the feedback. Thank you. That's certainly been our intent, and to assist with that, hopefully. So I was working through the National Planning Standards. As I say, I've made submissions on these before, and I think I've really concluded Hokanui's position on it is that the Sites and Areas of Significance chapter isn't relevant, and therefore it's entirely appropriate to have a Ngāi Tahu Cultural Values chapter. And the only new part to those submissions really was at 23. I've pulled out a couple of other signals, if you like, from the National Planning Standards that confirm that approach, and that Direction 17, which I think has had some attention today already, begins with if the following matters are addressed, so it's not a directive that they must be addressed. And then likewise, Direction 18 anticipates potentially other cultural chapters sitting in a district plan, so that supports the position being put by myself, and I understand it by my friend Ms. Chadwick.
You've sent us another 125 pages by the look of it, in terms of 5 cases.
Yeah, I saw that my team had did that, which a lot of them are cases you already have. So if you're short on time, there's probably nothing new in there.
Okay.
But I'd be happy to talk to that that was about some braces to make sure you had all the cases referenced. Don't print them. So moving over the page, page 5, the regional policy statement was raised in evidence by Transpower, and I wasn't here yesterday, sorry, but my submission really is that the relief sought by Hokonui does give effect to the RPS. The particular policy that Ms McLeod has pulled out is just one of the policies that sits within the Southern Regional Policy Statement, the Sites of Cultural Significance policy, but that policy, even in itself, doesn't direct mapping. So my paragraphs there are really just to submit to you that the objectives and policies from the RPS need to be read as a whole, and just pulling out that single policy isn't helpful to that exercise.
The RPS then goes on to provide methods which are mandatory and methods which are discretionary. And I think from memory, the recording of sites is one of the things councils are encouraged to do. And of course, it predates the national planning standards.
Yeah. And again, it's an encouragement. I was just trying to find. I think it's method 5 potentially. But again, an encouragement. I'd submit that the views of Runanga are really relevant to that matter. And again, it's not a directive; it's an encouragement. So that the approach being put forward does achieve or does give effect, to the RPS. I was just trying to find that method while we talked. Sorry, but local authorities will be encouraged to. No, got it. So moving now to section 6E, which I've just got open here. I hope it goes without saying that the relief sought by Hokonui is intended to give effect to or achieve the purpose of section 6E. And Ms McLeod has raised some concerns about that. I've briefly referenced the Port of Tauranga case, which I have raised in submissions with you before, which was just around the realm of section 6E, and that it's a broad section, and in that case the court was critical of the Port of Tauranga for not having appropriate regard to the extent of section 6E, and ultimately again I submit that it's for the Runanga to put their view on that to you. I certainly don't, the Runanga don't agree with Transpower that the relief sought doesn't achieve the requirements of section 6E and that relationship.
Have you got anything to say about section 7A?
Yeah, so I haven't put anything in writing. The Kaitiakitanga section 7A. I mean, likewise, I think it's for the Runanga to put to you how they wish to exercise section 7A and Kaitiakitanga, and it's obviously a matter that is to have particular regard to. So again, I think that consistent with the section 6E submissions, as a panel, I submit that you should put a heavy or high weight on what Hokonui is saying to you is the way they wish to exercise Kaitiakitanga in the Gore district. So that's my only submission on that point. Moving now to Ms. Beerin's supplementary statement, and I've sort of jumped ahead a little bit on this, but I thought I'd just briefly introduce the appendices, but the panel are probably now broadly familiar with them. There's just to background the intent of Ms. Beerin's work, because it's important to Hokonui to emphasise that the intent of this work, both it's been taken a lot of time and a lot of resource, is to respond to feedback from the submitters, respond to feedback and questions from the panel, to assist the council and the 42A report writers in getting a better understanding of how these provisions all fit within the plan. But ultimately it's to assist the panel in your determination. So I just wanted to background the context to that information, and I acknowledge it's a lot of paper and that timeframes are tight, but that's just life, and we're all having to work to those timeframes. So the gap analysis sits at Appendix E, and that's the landscape table, which I won't speak to the detail, but it's really, this is the linkages and interactions table that Ms. Behrens has gone through that expands on the joint witness statement work that was done with Courtney. So that's Appendix E.
It's very helpful, I have to say.
Thank you. I should have just gone to the appendices in chronological order, which would have been more use. But Appendix A, Ms. Behrens has pulled together some background guidance on the national planning standards, really just to assist the panel in explaining the background to her thinking as she's worked through those aspects. Appendix B is really a working table that is Ms. Behrens' summary or pulling together the provisions as they were in December, with the middle column being the proposed changes that she's included in the Ngāi Tahu Cultural Values chapter attached to her evidence. So it's to show the linkages between those earlier provisions, like Mana Whenua Objective 1, and then explained her preferred approach of where it should all sit in terms of her appendices. So I use that table quite a lot to help track where the provisions have gone, and it may help the panel with questions perhaps to do the same, but that's obviously up to you. And the third column is just to explain Ms. Behrens' thinking on her recommendation for you on each of those provisions. Then if we move through to the next appendices, which is the Accidental Discovery Protocol, so that's Appendix C. This is a protocol that was sitting in the Earthworks chapter, and there was some discussion in the December hearing about two protocols and cross-referencing of protocols, but in the process of preparing her evidence, Ms. Behrens has realised that working with Hokonui, that wording was a great start, so has added to the wording of that Earthworks Accidental Discovery Protocol provision and included it in that appendix. Without jumping into the detail, because there may be questions on it, I personally feel that could sit as an appendix, cross-reference through the plan, or it could sit throughout. I don't have a particular view, Ms. Behrens may from a planning perspective, but what's important is the wording and the content of it, which is in Appendix C. The earlier table at Appendix B resulted in amendments, so that's been included as track changes to the Mana Whenua chapter, the background chapter. Then we have the main gap analysis, which I've already spoken to at Appendix E, which I don't need to page turn. The Appendix F is the joint witness statement, and then that really leads to Appendix G, which, as I submitted earlier in my submissions, really I think hopefully is helpful to show where the teeth in these provisions sit and what changes have been recommended by Ms. Behrens in conjunction with Hokonui, and in particular the much more refined and focused approach being taken to these rule triggers, with the removal of a significant number of triggers for activities. And I think it's the last one. Appendix H is then the track change revised Ngāi Tahu Cultural Values chapter as sought by Hokonui. So it's sort of might be helpful to briefly introduce those to give orientation to your questions of Amy and I. Really, I've ad-libbed through my submissions, but I just, at 40, have summarised Ms Beerin's conclusions from her gap analysis, which is this 50-50 point that's come up a little bit today, that there's an inconsistent approach, including Ngāi cultural values in the provisions, and that sometimes they're explicit and sometimes there's a reliance on the overarching provisions in the chapter. So moving now to the refinement process that Ms Beirins and Hokonui have worked through together. These legal subs, and we were grateful for the extra day Ms Beirins had to prepare her evidence, but my subs went in before Ms Beirins. So I've just summarised really what's included in Ms Beirins' evidence about the refinement to the triggers, focusing on the set focuses on waterway setbacks, some particular height controls, but a reduction in those height controls, the removal of building size as a trigger. I mentioned earlier the addition of the servicing of particular development, to standards, and removing the consenting trigger or matter of discretion for the actual activity itself. And lastly, but importantly, some amendments to the earthworks provisions, which I'll let Ms Beirins speak to, but as I signalled earlier, that's heavily reliant on the accidental discovery protocol. So I did speed up as we worked through the submissions, but I'm conscious to leave time for questions, but hopefully I've introduced those provisions and happy to take questions.
Do not feel constrained. We want to get it right.
Yeah.
And we've talked about it's just for personal reasons we will need to take a break each hour. 5 minutes, just yeah.
That's fine. Yeah. No, I appreciate the steer. So I think that's really all I wanted to say on Ms Beirins' evidence. And then really to conclude, that Hokonui maintains its position that the amended relief will provide greater certainty to plan users about the outcomes sought. And the refinements to the provisions, which I've just very briefly spoken to, have now been detailed by Ms Beirins in her evidence from the 12th of February. And that refinement is directly in response to feedback from submitters, and Hokonui are listening and are keeping those triggers as refined as possible. And it's limited the consideration of Ngāi cultural values to the key activities where Hokonui have identified the requirement for an assessment. And that assessment, and Terry can speak to this, but it may be as simple as a quick phone call, or it may be a cultural values assessment. It will depend on the particular activity. And in our submission, that the Hokonui Runanga relief is the most appropriate way for the Council to meet its obligations, both in terms of Section 6, 7 and 8 of the Act, and also give effect to Part 2. So happy to take questions, either now or as we work through the afternoon.
I guess a lot of what you've said is an intro to what we're about to hear.
That's
but if there are any questions from the panel that just relate to the legal aspects?
As we know by now, I've always got questions. So, paragraph 7 of your legal submissions. Am I correct in assuming that there is nothing in higher order documents that compels differentiations of areas based on their significance? So, down in your submissions, you've pointed to the RPS and that it's not a compulsion to differentiate areas based on their significance.
Yep.
So I am testing, is there anything at all in the higher order documents from the RMA down that compels that occur?
Just so frame up my response correctly. So it compels that sort of differentiation of significance. Is that in the context of cultural values?
Yes, specifically in the context of cultural values, section 6E, 7A and 8, and anything that comes down from there. But primarily section 6E, which, as I canvassed with Ms Scott, does not have a significance test in it, i.e. it's referring to a relationship. And begin, it would have to be something further down the chain that required that. So
no, so there's none that I'm aware of, and that the none of that statutory framework from the section 6 right through doesn't attempt to define what will or won't be significant or put a threshold on the relevance of significance. And I think that's that's likely being driven by section 6 talking about the relationship that Māori have, and that drives the need for a discussion about that relationship and what the effects of a proposal might be. So quite different to say the outstanding natural landscapes has an appropriate test, and as you say, there's significant tests elsewhere in the statutory framework, but no, there's not a directive sitting anywhere above the district plan that puts that threshold on cultural values that I'm aware of.
at your paragraph 13C, you're saying no additional consenting requirements are introduced. The proposed NTCV chapter relies on existing rule triggers and matters of discretion that form part of the notified PDP. Is this an important limit to scope? I.e., if there were additional consenting requirements introduced, that would have us, would that have us re-examine the matter of scope?
Yep, no, that's a good question, and it touches on a point we had an exchange on earlier in the day, that I don't think it's a black and white test that if you're adding a rule it's outside scope, and if you're not it's inside scope. But my submission is that where there's already consent triggers sitting there for an activity, it's more likely you're not going to fall foul in terms of scope if you're adding a matter of discretion to an existing rule or a matter of control. So I think it's relevant, but it's not the only consideration. I was pondering it over lunch. If you had a policy that said avoid buildings in an outstanding natural landscape, but no rule trigger for buildings in an outstanding natural landscape, I'd submit to you that's an example where I would submit you've got scope from the policy, and there's an issue and a consequential relief needed to put in place a rule. But that's in the context of a clear directive policy that most plan users would be able to understand.
Just an obscure question, it just popped into my head about scope and thinking back to Federated Farmers' concerns and the context within which cultural values might be recognised. The Federated Farmers' concern is with traditional agricultural day-to-day practice,
yep,
which would not actually be Ngāi Tahu cultural value activity.
Yeah, absolutely right, and it touches on a point, and Terry may like to add something to this too, but the intent of the refinement of the rule package and the particular activities that will trigger the need to consider the Ngāi Tahu cultural values, from Hokanui's perspective, wouldn't impact those day-to-day farming activities at all. And a key reason for that is they're not needing resource consents already, and that won't change with the relief being sought. But even if they do need resource consents, they won't always have to consider cultural values.
So in one respect, you're reliant on the accidental discovery protocol. Farming people are often digging holes to do this, that and the next thing, and they might discover something.
Yeah.
I'll turn that off. I thought, yeah.
At least it was you. And we were talking over lunch, and I'm not sure whether it's helpful for context or not, but we play the counter argument, and if everything was to be mapped, every area that there was a risk of uncovering an artefact or whatever, there would be extensive mapping everywhere, and I don't think that's the outcome that Federated Farmers want either. In fact, it's the outcome they're opposing in the Timaru District Plan. So it's where Hokonui have landed. This approach is the balanced approach. It's not intended at all to prevent those farming activities. It's just to have safeguards in place where they're necessary.
So just adding to that, like I can't see how these activities are any different to what's in the operative plan now that you had to consent on. I mean, just because we've written them down, it's caused some concern, but really there are not many changes in the operative plan as it stands.
And that's my take as well, and that the goalposts haven't been moved that much. I do genuinely feel it's a perception or a fear that's just not justified when you go through those particular triggers. And from Hokonui's perspective, I'd urge Federated Farmers to go through that table and provide their feedback on it, because I think it would be a really useful exercise.
Any other questions from the panel?
So I don't think I've asked you this yet, but we have talked about it today, around this position that's been advanced now by Transpower and Federated Farmers that because the entire district was declared a site of significance to Māori, if it is thus, then the SESM chapter becomes relevant to the district because the SESM language was used. And so if we accepted that position, which I know is not your position, what do you see as the logical consequence of accepting that position?
Yep, so just for the transcript, that's not my position, but to answer your question, if the entire district is a site of significance, which is actually just a heading in the National Planning Standards, there's nothing more really to it than that. It's not a defined term. I say it's not a defined term. I probably should check that, but I don't think it's a defined term. The outcome available really is the relief being sought by Hokonui through the Ngāi Tahu Cultural Values chapter would just need to slot into the Sites of Significance chapter as being, but with the same objectives, policies and methods that are being sought. If we're going to work in the National Planning Standards sort of theoretical approach, because you've got a map site and provisions to manage that map site. So then under Direction 17, I think we get pushed into a corner of it needing to sit in that chapter.
I think the whole valley prior to settlement was significant, but it just hasn't been sort of introduced or scripted. But it has. You go from the Mataura Falls to the Pumahaka, all in Tutoro. So it just hasn't been descriptive and hasn't been written in. And we deal with that on the consenting basis. A lot of consents don't even need our intervention, and we're always sort of swapping and changing back to the planners and the inquiries that come out of the council. Does this need a cultural impact assessment? Does this need, and usually it's just a tick off and it's just sent back. It's quite a fast exchange. The major ones are just the industries on the discharges and the air pollution and things like that. But we've got some major consents coming up soon, which all affects our cultural values, not only the councils but also Fonterras. And we just got to work our way through it, how we actually remedy the solution or get to the solution.
Terry, do you believe that the charter between the Gore District Council and Hakanui Runanga is helpful in this process?
Yeah, I think it's as Keith said, and it's up for review, or we're just going to review it, and if there's any amendments and tweaks, well, then we'll tweak it.
Can a farming person, or has it happened, or unexpected, a farming person will contact the Runanga directly and say, look, I'm going to approach council for a consent, or I'm considering this activity. What's your steer on it?
Look, our administration sector deals with a wide range of things from grants to environmental inquiries, health and well-being, and all that, and we deal with it on a daily basis. Sometimes it might be a bit light, but farmers do actually come in. Gold miners, people that are looking for consents up and down the river on their landing sites. We've just actually taken a position on dairying. I think the other three Runanga have actually, they don't want any more stock on the farms and that, and our position is as long as it's sustainable and it actually fits within the requirements of the RMA, and then we'll support it. If they're going to increase the herding and all the rest of it. So I think we've taken a different approach where we're not just saying no. We're sort of saying, look, this is an option. If you can actually prove this is the option, well, then we'll support it 100%.
I think the only other point, just to tie off the MPS, that from my perspective, that the only way that the argument that that federated farmers are running could have traction is if the MPS said that the only way to protect cultural values was to map them and put that mapping as a tool in the Site of Significance chapter, and that's not at all what the MPS says. It just says if you do mapping, it needs to sit within that chapter.
It's a nice segue to my next question, which is to do with the standards that you discussed at para 23B. And I've asked this question a couple of times already. I'm going to ask you now, what is your view of the must in this mandatory direction? Does this then point us towards the NTCV being in this part of the plan rather than as part of strategic directions? That's the
Yeah. Yes, as a chapter, I think the must directs that the chapter would need to sit under that heading. Not to preface what may be the second part of the question, that doesn't mean you couldn't have strategic or objectives and policies sitting in the strategic chapter relating to cultural or historical values, and there's examples of those around the Takawā as well.
Okay, so my follow-up is it relevant in terms of the relationship between cultural values and the RMA definition of historic heritage? So obviously my reason for asking this is that I had this exchange with Transpower yesterday around their Naseta, because the RMA definition of historic heritage does have this bit around sites and areas of the Wāhi Tapu, right?
Yeah.
But it also has just cultural heritage,
yeah.
right? So when I think about those two things, I think about Wāhi Tapu and sites and areas of significance to Māori as kind of like a subset maybe of cultural heritage. And is that another way to think about what the national planning standards are telling us? So at the moment they say, if you're going to do mapping of sites and areas of significance to Māori, stick it here in the, that part of the structure of the plan. And are we talking about cultural values in that sense of cultural heritage that would fit under the historic heritage definition? And is that another reason why it might sit in this part of the plan? Or is that limiting what we understand cultural values to be?
No, I think that's a fair connection to be making. I mean, starting with the definition of historic heritage in the Act, I agree that it starts with that broad, just as cultural as a quality, and then it gets to the more specific or potentially the more tangible values, and it's often those more tangible values that mapping captures as well. And then there are there are also intangible cultural values that exist. So no, I'd agree that the mapping or identification focus in Direction 17, it would make sense that it's colouring what they've put in Direction 18 as well. So I'd agree. So it's off the point, but just it occurs to me, I'm not sure if it's helpful or not, but we often end up in discussions at district plan review hearings around strategic directions and does something need to sit in that to sort of have a heightened direction or a heightened value to a decision maker. But to my submission, that it's just that the strategic directions cover the entire district, that particular objectives or policies sit in those strategic directions. They don't actually have a heightened weighting or a heightened relevance to an objective that sits in an area-specific chapter or an activity-specific chapter like earthworks or whatever. So I'm of the view that provided it makes logical sense and is clear in terms of legal weight and relevance, it can sit either within the plan or in that strategic chapter.
Paragraph 24, I wanted to explore, Ms. Scott raised the matter of rule of reason, and she actually talked about the nature of cultural evidence in this process, and she was saying that it differs from other processes she's been in because the cultural evidence is not describing the basis of relationships and history in the district. That was her submission to us yesterday. And so I think it would be useful to have a response on rule of reason as it applies to in your submission, and whether we're lacking anything in terms of cultural evidence describing the basis of relationships and history in the district.
I disagree with Ms. Scott's position on this, and I'd wondered if she hasn't read, in particular, Joe Brand's evidence from topic 3, chapter topic 3. It to me touches on this point squarely, and I think there is a robust evidential basis that then has flown through these provisions as we've worked through the process. And Terry also provided evidence in that hearing as well, from a slightly more practical Runanga perspective.
And I think that's what I was hearing, was that she was referring to Mr. Nicholas's evidence, but did not make reference to Ms. Brand's.
Yeah.
So that's, thank you. And then I wondered, because I have explored this with others yesterday and today, to what extent the statutory acknowledgements present in the district assist and section 2111 of the N2CSA. So I've had a response from Ms. Chadwick on this, and asked it of Transpower and of Federated Farmers. So I've got a range of views, and I'd like yours.
Yeah, thank you. So the statutory acknowledgement is an important part of the puzzle for this discussion. I mean, a key part of the Claims Settlement Act and the statutory acknowledgement is that it's an information tool, and it provides a statutory framework that says Hokonui can turn up to you as a panel and say, here's some more evidence as to the significance of this area. I mean, that's one of the purposes of statutory acknowledgement areas, is that they can be used as an information tool for local government in plan making.
Is it evidence of significance, or is it evidence of relationship?
It's a good question. I think it's evidence of relationship. I don't think it's making a direction or giving a heightened sense of significance. I think it's a statement of relationship relevant to your decision making. I mean, at a more practical level, it's very relevant, for example, to notification and processing of consenting, and that's where we're often using them for Ngāi Tahu.
Oh, this is why I'm asking this question. So that's one way that they can be used, right? That they're commonly used. But I guess why I'm asking the question is, when I look at section 2111, it's not bound, it's not telling you in what process you might refer to it. And so that's typically where it is referred to. And so when I asked this question of Ms. Scott, she said, well, you know, it might be more relevant to freshwater management, right? And I could see why she said that, because I asked, and so I'm going to ask you as well, that statement of relationship that's there, we know that the entirety, pretty much, almost, of the Gore district is within the Mataura River catchment, and the bits that aren't are in the Mata'o Clutha River or Oriti catchments, and they have statutory acknowledgement areas. So I was looking at those to try and understand to what extent they are already telling us that the relationship exists across the whole of the district. That's my reason for asking those questions.
Yep.
So, and probably when I was using the term catchment, that made Ms. Scott immediately think of freshwater processes, which obviously I can see why. So what I want to understand is the extent to which those statutory acknowledgements are describing something beyond the waterway, like the lands and the waters, you know, the catchment. And if they are if they are describing a relationship with not just the river proper, but the catchment that feeds the river proper, then you know, they might be contributing something in this process around relationship and relationship to the district as a whole. And I just want to understand what that contribution is.
Yeah, Terry's keen to jump in on that one too. So.
You know, I think there's one thing under the Hokonui Runanga, it's in a really unique position where we go from from Milford Sound, or from Wanaka, from Hawi across the Milford Sound down to the subs, and we find ourselves in the three catchments that you just noted: the Southland District Council, the Clutha, and also the Gore District Council. And it's always been a hard ask, and Mary used to always pop it up, is that we only get resourced to actually represent one side of it, which is the Murihiku side. We don't get resource to do the Otakau side, but we've got to operate in the Otakau side too, and the Southland District Council and all the rest of it. So we're always sort of going through those statutory acknowledgements and all the rest of it, and we've had to learn the whole lot. And when we get into the consenting difficulties, like we're involved in the Santana mines now, because we're in that area. So we've got to sort of educate ourselves up again and just make sure we're on game. So it's a unique little runanga that's got a heap of responsibilities and care and protection, and also not only for us but in the national interest.
Yeah, no, that's helpful, and I think that all I'd add to that, to respond to your question, Commissioner Bartlett, is that I think we need to look to what the statutory acknowledgement says to help answer that question, and that it is about the Mataura River itself, but when it describes what that relationship is, it broadens that out to Mahinga Kai, the Muri of the Mataura, the physical and spiritual elements, I think it is, not connections. So I do think the statutory acknowledgement does broaden that relationship beyond just the river itself or just the freshwater aspect itself, but the more Maori world view, if you like, of all that being connected, which is a relevant evidential matter for your decision making.
And would the other evidence for the relationship across the district be sitting also in the iwi management plan, which feeds this process as well?
Yes, yeah, no, absolutely. Which I've done submissions on it. Right, I think it was in topic 3. I haven't put anything in these submissions, but I'd just reference back to those in terms of it being a relevant matter, and it's a very robust document as well.
Which segues nicely to my next question. In your paragraph 34, I'm wanting to ask, so this is where you're talking about Port of Tauranga, and so I asked this question of Ms Chadwick because I had a read and something jumped out at me when I read it, which was that the port didn't have a defence, that it didn't understand or couldn't understand how to address mana whenua concerns or interests or values, and that the answer to that from the court was that there was an ability to utilise materials that were available and information that had been made available, and that the other responsibility was consultation. So I just wanted to check that that it's a combination of engagement and utilisation of materials that mana whenua have made available. It's the combination of the two.
Yes, that's my interpretation of that case, and also the court's view in general and how to manage cultural values. That there's a consultation is a key one, or the key one, but also various other sources. And in Port of Tauranga, I'm fairly sure the word the court used was a complete disregard, that the port had shown a complete disregard for Section 6E. After a lot of other things that happened following that, the consent was ultimately granted. But the court was very firm in its criticism of that lack of engagement and that lack of consultation and genuinely understanding the values.
Yeah, so I'm kind of interested in this point that it's not available to a resource user to say, I don't understand your worldview, I don't know how to address it. If engagement opportunities are available and materials are available. I mean, that's the crux of it, right?
That's the crux of it, and I think the other point that I would add to that is submissions being made that Hokanui can't resource or can't respond to this engagement is quite offensive to Hokonui. I mean, they're fronting this process, they're fronting the engagement, and they are ready to do it, and are doing it already. So that's certainly not a risk from Hokonui's perspective of a district plan pushing people into an engagement with them. And in fact, it's often going to be the best way to get an efficient, quick answer, I suspect. Interestingly, in the Fast Track Act, the information requirements are slightly different to the RMA in that they say not just assess cultural values, but to explain and sort of put in a chronology your engagement with relevant iwi. So I think in a very fresh piece of legislation, it's quite helpful that additional steps being added. It's not just about say what the effects are, but say how you've actually gone out to learn about those effects.
Paragraph 35, I wanted to check with you, when you refer to outcome in there, are you meaning the preferred method to achieve the outcome?
Oh, sorry. Yeah. So it should just be a particular resource management method is required to meet. Yeah. Method to achieve the outcome. Yeah. Yeah. Sorry. Method or measures or tools.
What we've heard from Ms. Scott, definitely Ms. Scott yesterday, was that there's some inconsistency in your legal submissions to us around describing significance. And so I wanted to check with you at your paragraph 44B, there are references in here to natural features or landscapes of importance to mana whenua, different, and I wanted to understand, is that somehow different to the concept of sites and areas of significance to Māori?
Well, no, sorry, that's going, yeah. I'll just reread what I've written here, bear with me. No, I mean I'll put that in the context of semantics, or I'm not intending a different meaning to that. They are areas that have importance to Hokonui, as with a different approach, sites and areas of significance to Māori. So I'm not putting an intentionally different weight or significance on those landscapes by using that terminology. And sorry, just to add to that, so there's no magic from my perspective to my word importance versus significance. Sorry, I just was processing your question a bit more as I was answering it. And that there's a relationship for mana whenua to those landscapes. Yeah.
And it's the relationship that's important.
Yeah, it is the relationship that's important. And I'm certainly not saying that importance is different to significance.
So has that helped us get to the difference in thinking in some ways, because here what you're putting towards us is the significance is the relationship, the importance is the relationship. It's not static to, it's not confined and static to a area, a site.
Geographically delineated map.
So it's the relationship that's significant and the relationship that's important. Okay.
And the statutory hook that I'd keep coming back to there is section 6E, which is focused on relationship.
Very last, thankfully everyone will be saying, thank goodness she's over. Yeah, it
Not-
was more just
not at
like
all.
paragraph 47. Are there any adjustments to make now that Ms. Beerin's evidence is available? I think you've probably answered this
No.
today, but it's worth checking.
I'm glad you asked that, because when I reread these last night, I thought, oh, that I might get asked about that, because I hadn't had a final version of Ms. Beerin's evidence. So no, the Ms. Beerin's version is the version being sought by Hokanui. There's no amendments to that. That's right, isn't it, Amy? Oh, yeah. Sorry, I just remembered, there's one very minor point which Amy will speak to. But hopefully that gives some comfort that the I don't want to call it a future work stream, that the exercise from Hokanui's perspective of pulling Appendix G into the district plan isn't a major task. And it isn't sort of a rolling exercise, it's really Appendix G.
So we will take a 5-minute break and come back to Amy
Great.
on
Thank
that.
you.
Thank you.